Thank you. I'm from University of Sydney, and the research centre that Garner, we're very appreciative of the ad that he gave us this morning in his session. I'd like to start by paying my respects to the owners, the traditional owners of the land, and to share with you the artwork on the left, which is by one of our colleagues at the university, Lynette Riley, Aboriginal woman from Dubbo, who's done some great work around on a project we're in with the Wiradjuri language. But she is an artist who designs capes and does beautiful carving on them. She actually did the cape that Linda Burney used for her maiden speech in Parliament, which is fantastic. So in overall, I'd just like to give a bit of a context. Silky has talked a lot about the impact and so on of young people, on children and young people. We've got increasing awareness, clearly, of family violence on children, and often with that phrase, exposed to. But I'd like to talk a little bit more and direct it a bit more to victims in their own right, and link it to children's agency and the strategies that can be used. The other aspect is looking at the increasing awareness of children's views. And we've got some great research now through ANROS and through the Australian Institute of Family Studies, where some of these views are being reported, and again through surveys and so on. And the two other reports there, one by the New South Wales Children's Advocate, which is talking about children's experience in care. And again, the same sort of themes come through there that I'll refer to later, about the dismissiveness in which some of their views are treated, and also the difficulty of dealing with any legal processes. And the other is one by Bernardo's, "The Truth is, the abuse never stopped." And if we look at the last aspect of that, around the constraints and the diversity in practice, and linking those two aspects. So how do you deal with children who want to say something, who need to say something about their experience in a process like family law? And there have been a number of people who've done some fantastic work in that area, and there are a number of advocacy groups. We know that there are a lot of issues around this. Just wanted to start too with just thinking, what does home mean to children? Because what's at stake for them in this is the safety and security and feeling that they have a physical space, a space of their own, and a space where they can feel safe and have relationships that work for them. And there's some really good work that was done on that by Belinda Failberg and her colleague, Natalia. And so their research around that and talking about the inviting the messy, the hidden hurts and the humiliations. And I assume that that's some of the sort of thing that Silky's talking about, or the young people are talking about there. All of those things, the reasons why children with disability, the reasons why those who are gender diverse will act out, because they're not acting just from what they've seen, they're acting from the humiliation and the hurts that can go deep. But in the area that I'm talking about now, there are several touchstone issues. One of them is contact. What right children have to say that they do or they don't want to see a parent, and how that happens. That's actually also an issue for children in care. And the compliance issues, and what are the implications for the parents, or usually the mother, if the child does not want to, or if the mother does not feel that it's safe for the child to have that sort of contact. And again, some really good work in Scotland in that area. This is a report that just gives some really good background for those of you who are not really familiar with this area about parenting arrangements. And again, a big report that was done at the Australian Institute of Family Studies by Ray Caspiev and Rachel Carson. They also, and I'll be drawing on some of the work that they've done to the Australian Law Reform Commission report or inquiry into this area, and the submission and the reports that they built into that submission. So just to give, again, a bit of the legislative background, in the Family Law Act, in terms of determining what the child's best interests are, there are the primary considerations and the additional considerations. I'll come to the additional in a minute, because that has implications for children's agency and participation. The primary considerations are A, and this was what was mainly changed in the 2006 rewriting of the Family Law Act, which is the benefit to the child of having a meaningful relationship with both parents. In 2012, there were amendments that were brought in to prioritise the second of these two, which is the need to protect the child from physical or psychological harm from being subjected to or exposed to abuse, neglect or family violence. And you need to go to the definition of family violence in the Act. I'm not going to go into all the details of that. But the change from 2006 to 2012 was because there were so many people who were unhappy with the way in which that was working and the need to actually prioritise children's safety. I think what we can see from the research and inquiries that have gone on since then, that it actually hasn't achieved all that people were hoping for in terms of that prioritisation. If we look at, and that's what I'm referring to at the end, there's little evidence really that the greater weight is being given to B, safety, child safety, over the meaningful relationship. And there's a series of things that I'll be talking about during this. One of them is around the views of family law professionals, and I'll show that in a minute. The other is analysis of reported judgments, and again, that's one of the AFES projects. And in fact, one of my students did an analysis of all of the 2019 relocation judgments and looked at what happened in those. And that was important because it was the year prior to COVID. And once that hit, all sorts of things changed. And then the other big issue here in terms of contact is it's not just the impact of the family violence on children, it also is transmitted or it's mediated by the changes in parenting of the mother, and we are mostly talking about mothers who are the victims of family violence along with their children. And it's how it impacts that and how that negotiation of safety and so on can make children feel as though their voices are not really being heard in the process and they're being silenced. This graph comes out of the submission to the ALRC. And what that basically shows, if you look at the graphs on the left, which is about how important or how adequately do you think that the way in which these cases are dealt with take account of children's right to have a meaningful relationship with both parents, you can see it's pretty high. It's, so judges, judicial officers are saying 100%, lawyers 88%, non-legal professionals 83%. Then if you get to what extent is child safety adequately being managed through this process, it drops. Not so much for lawyers, for judges, but it drops quite dramatically for both lawyers and non-law professionals. And these are the people who are working in the system all the time. This is their views of what is happening in the system. If we look at additional considerations, and that's what the Act has divided up, the first of those are any views expressed by the child. So they become an additional consideration, not the primary consideration. There have been various concerns about how the Act how simple it is for these decisions to be made. And so then if you get down and you look at the other, so I haven't put, there's a whole list of them. I think it goes down to about, might even be down to N or O. There's a lot of considerations that can be taken into account. But I've put up those that I think are really critical. And that's if the child is Aboriginal or Torres Strait Islander, if there's any family violence, and if there are any family violence orders. All of those things need to be taken into account. And then, of course, there's whether it's preferable to make any other order. The definition of family violence is one that specifically appears within the Act. And it's reasonably detailed, but if you read it fairly clearly, it actually focuses much more on physical assault and violence. There's not, I mean, I know that it's being interpreted a very good thing more broadly. There's a lot of concern that coercive control hasn't been properly taken into account in that, and that's one of the issues that a lot of the advocates in the area are really wanting to push. And the emotional abuse. And of course, there's all the other aspects of financial reporting and stalking and what's also referred to as systems abuse by the perpetrator, where they use the legal system in order to make life so much more difficult for the mother. And usually they have means they may have more financial means to bring it back, keep bringing it back to court. And just hope that that the other party will give up. And if you look at the way in which the court, cases that come to the court, there's a very small proportion of cases actually get to court. It's only around about 3% of parental separation matters that actually get to a judicial determination. There's a substantially more than that start but then finish by consent. But is it consent or is it giving up or being overridden? But the vast majority of cases, thankfully, if they really are consent, are by parents talking to each other and sorting things out before that. But the ones where family violence is involved are much more likely to go to dispute resolution and to full judicial determination. Those are the cases that are really difficult. And in fact, what's been happening over time, if you look at cases, those judicially determined or those cases that really are contested in the family court, they look very much like child protection cases. They have all the same drivers: substance abuse, mental health, family violence, and poverty, and so on. What they don't have, which is interesting, is that they don't have the overrepresentation of Aboriginal families because they don't tend to use the family court to the same extent. So the rider for all of what I'm talking about is that we really don't know very much about how this happens within Aboriginal families and communities, and we need to, Aboriginal families and communities, much more needing to do work in that space. It's an area where the research, it's no longer research on, it needs to be research with and research by Aboriginal researchers and so on. So as I said, they look very much like that, but there are a whole lot of the different sorts of impacts that we've talked about, and it varies. I mean, it's a different matter when you've got an infant with a child who's at school or not yet at school, because the parenting orders will alter. And of course, when you get to adolescence, what courts are well aware of is that adolescents can start, voting with their feet, and they just refuse to comply, or they make it very difficult. some of the research that we have been involved in, police have been called to try and take children who are highly resistant to contact or to time with the other parent, and they were mostly fathers. So what we are seeing in the what comes before the court, or what is and comes within court files and comes through the administrative data that AFES has been able to look at, and the judgments and so on, is that there is a lot of the cases involve family violence. It's a very common process. It's a very common characteristics of the cases in which, and the more troubled they are and more contested they are, the more family violence is involved. So there's been an increase in both physical and emotional violence. There's been an increase in children exposed to family violence from about just under half to about 58%. It's not huge, but this is since the 2012 amendments to the legislation. Not much change in those where it was deemed to be the child who was the victim of family violence. It stayed reasonably stable. If you look at where children's views are a factual issue in the case, and this is from the analysis of the court data, only 8% of cases. Now, given that children's views are an additional consideration, that does seem to be a very small number. And I was involved in doing research. Actually, my colleague Patrick Parkinson and I wrote a book on children's voices in family law matters in 2008, based on a lot of work. What's a bit disturbing is that some of that hasn't changed that much. You'd really want it to have changed more than it has. These are not big increases, but what the AFES report is showing is that there's actually been an increase in cases where manipulation of the child's views, or the implication or the claim by the other party that the child's views have been influenced by the other parent, that's increasing. And that's consistent with some of what we're seeing in terms of concerns by family law professionals. If we look at, if we want children to have some say in the process, I mean, these are their lives. They have a right that somebody who's making decisions at least takes into consideration what their views are and what would work for them. If you want that to happen, there are various ways in which it can. What kids want is to be able to talk to the decision maker. Now, the decision makers being their parents is the most direct route. Doesn't always mean that it gets that they get what they want, and mostly the children that we were involved in talking to through that research don't want to have the say, they don't want to be responsible, but they do want the person making the decision to consider what they want and to really take it seriously. So it can be informal. It can be informal that's external, where it actually happens through some sort of counselling, child inclusive or mediation process. Alternative dispute resolution mechanisms. Some children see FDR people. A lot of them don't remember who they've talked to, quite frankly. They're talking to lawyers, and if they're talking to lawyers and counsellors and so on, they don't always know exactly what those roles are. And then there's a newer process, which is the child impact statement, which is like an earlier form or a simplified form of family report. And then you get to the formal judicial proceedings. In the most contested of those cases, where things are likely to head down the judicial determination route, there's a family consultant who writes a family report, or a private expert who writes a report, and an independent children's lawyer. What do we know about from the research and from what works for kids in terms of whether or not they're able to give their view and feel that it's able to be given, that it's got a receptive audience, it's going to fall on fertile ground. The main thing is that they have an ongoing relationship with the person they're talking with, which is ideal if that can happen. With a family report writer or with an independent children's lawyer, highly unlikely. Same in child protection. So if that is not possible, which it isn't in those roles, they need information as to how anything they say is going to be used and who's going to hear it and what might be the repercussions. What does confidentiality mean? How do you explain that to a child so that they really know who's going to hear and what that might mean for them? Are there adults who are actually willing and able to hear uncomfortable truths? And it can be very difficult for those sitting on the other side. And then at the end of the process, they need some sort of feedback on the outcomes and the reasons for the decisions. And this is where we often fail. We don't often go back to kids and really tell them what went on, and then they have to work it out for themselves. One of the interesting aspects that we've seen in UK and also some judges here, including in child protection, judges, and if they have the time, will write a letter to the child that can go in their file, particularly in child protection, but will stay there so that when they look at their file later, they can understand what was it that the judge took into account? What was he trying to achieve? There's a really lovely statement by a judge in England in one of the cases. Very happy to share it. So, what do children say they want? This hasn't changed since we did our research. It seems to be pretty consistent throughout. And it's consistent in family law and child protection and in other areas where kids want to have a say, but not necessarily have decision-making process. They want to know what's going on. Very reasonable. They want to have their views taken into account. They want to be treated with respect. And this is one statement that I remember from one of the girls. She was about 11, I think, when I was talking to her. She said, "This is my life. Why is everyone talking about me as if I don't, as if I don't exist?" And I think that there's this sort of abstract child notion rather than it's this child that we're talking about. And I know there are some judges and child protection magistrates who actually like to have the picture of the child in front of them so they know this is the child I'm making a decision about, not an abstract person, not an abstract concept. They want to have workable, flexible arrangements. I mean, their lives change, circumstances change, they get older, their needs change, circumstances change. But really important to kids is that they want to protect the relationships for those they care about. They don't want to hurt their parents. They don't even want to hurt parents who've been hurting them. And they want to maintain that relational ethics. But not all kids take the same view, not even within the same family. You can get some very different views amongst kids within the same family. What we found and has come out from overseas research too, is it's the children who've had an ICL, who've had a family report in sometimes a couple of them, and it didn't work for them, and they have just had it. And they're the ones who say, "Let me talk to the judge. I want to talk to the decision maker. I'm over this. I do want to have a much more direct role in it," because they now don't trust the interpretation that adults put on their views and the way it's conveyed. And they've got good reason not to from their own experience. So those are generally very strongly held views, but usually it's after a whole heap of experience. Of course, there are some children who have a very strong view very early on in the piece. So, what do the professionals they deal with? What are their views about how children's views should be dealt with. But there is certainly, I think, the rhetoric and I think the sincerity in a lot of space for professionals to say that they think children should have a voice, that their views should be considered. And it is Article 12 of the UN Convention on the Rights of the Child. But that they shouldn't be the decision makers. Well, most of the kids, as I said, are in agreement with that unless things have gone really pear-shaped for them. They also think that safety has to be a key issue. So do children. They want to be safe, they want to be secure. Where it tends, and children can also feel that they're under a lot of parental pressure, but what they tend to be much more concerned about is the potential for manipulation. And in some cases for children to be manipulating. That tends to be less spoken about, but it appears in some of the areas of discussion. And their concern, quite reasonably, is not to put kids in the middle of the decision, and certainly not to put them there if there's nothing they can do that's going to change the way the decision falls out. So, what's the context versus reality? If you remember go back to what I was saying about what's the invitation to participate? Is it real? Is it really genuine? And is it with somebody that they can have an ongoing relationship with? Not in the way that this is generally set up. If it's a family report writing process, then it's generally a one-off, and it's often a meeting in an office, or it may be an observational process in the way it's carried out. And if you're a parent too, how comfortable would you be knowing that there's someone sitting behind a glass, you're behind a mirror, watching the way you're interacting with your child and whether you're playing naturally and you can feel relaxed and comfortable? Not many of us could. So what we hear from kids here, when they're asked how do they experience, if they remember it and they know what was going on, there are some children who say it was a betrayal of trust. They didn't really tell me how my information was going to be used. I got in the car and Dad screamed at me the whole way home. What did you say that for? And so on. The other is that they felt that they weren't heard, too young. They were silenced, dismissive. They didn't want to hear what they were saying about the issues in their family, the adults involved. They weren't welcoming of that news. They didn't feel that it was a transparent process. And so in terms of dealing with this, we need more information and more research and so on about the transparency and the accountability of this process. There's a really interesting paper by Jeffries and so on about selective silencing. Very similar issues for independent children's lawyers if you ask children what their views are. But there is, I'm not saying it's all bad, there is a diversity here, a mixed view, that some are very happy and think that they were really treated with respect and so on. But again, frustration and distress and confusion tend to be quite common reactions. So in summary, the ALRC made various recommendations, and I think the first of them is around some of the legislation and simplifying that. There's still action being taken around that. There's certainly recommendations about transparency and accountability and accreditation of those involved, and I'm talking about family report writers and independent children's lawyers. And there's continuing concern about raising allegations if they're not accepted by the court. Now, the numbers in the 2019 relocation judgments case were not big, but what they showed is if the parent raised allegations of violence and they were accepted, then the chances of them being able to relocate were about 2 to 1. If they didn't raise them, about the same odds. If they did raise them and they weren't accepted, then exactly the opposite. So their chances of being allowed to relocate were halved. So it looked, now there are various things that could be going on there that I'm not implying anything about the way that it's punitive. There may be other considerations. So finally, the main point is about increased understanding of what children want and doing research in this area, and that's what Trish is going to be talking about, the difficulty of doing that. But the bigger issue is that Aboriginal children and families are not present, to my knowledge, or certainly not talked about in this research. Thank you.